Ooh, I just realized I can see who all's on it. There's a lot of friends on here.
Yeah, when we did the last webinar we did, someone was joking that the speakers, they got promoted to panelists and they suddenly had a lot of control over Zoom. All right, well, it looks like it is noon, so I'm sure we'll get some more people jumping on soon. But we'll go ahead and get started. Thank you all for attending. My name is Aubrey Weatherford. I'm the one who's bombarded everyone with emails, but we're excited to get to partner with the Clerks and Treasurers group to provide some virtual training for you guys, since we know the Clerks Conference at OSU got canceled this fall. So hopefully this will be a good opportunity for you guys to get some training in and also get some credit for it. So today we've got Matt Love with OMAG. I'm sure you guys have heard him speak before. He's always great and always wonderful to help out with things like this. So I'm going to turn it over to him. Like I said, just make sure your name is showing up or your Zoom name is on there. We will be checking you guys off from the participant list to make sure you guys get a certificate. So we'll send those out, and we will also put these slides up on the OMMS website after the session. So if you guys are planning to participate in future trainings going on in the next couple of weeks, this will be the same Zoom link every week. So just wanted to mention that as well. So save that and we'll send out email reminders as well. But I'll turn it over to you, Matt.
Thank you. Well, it is good to sort of be with all of you. I was mentioning for anybody that's jumped on, was nice to see the list of attendees, and while I'd love to be able to see everybody's face and be able to be with you in person, this is the second best way to do it. A couple of years ago, medical marijuana came to Oklahoma, and there was a lot of uncertainty, a lot of questions, a little bit of panic, a lot of rejoicement by some. But we obviously had to get ready to confront issues, and we had the benefit of not being the first state to have to deal with this. So we do get the benefit of learning from some of our colleagues in other states. But what I wanted to talk about today is talk about some of the workplace implications of medical marijuana and spend some time talking about specifically possible impairment by employees in the workplace and what to be looking for and when we might be able to have enough to send somebody to get drug tested and when we may not. So let's see how well PowerPoint works in Zoom. Look at that. All right, so first place we're going to start is with the actual medical marijuana statutes and what they provide for when it comes to employment. The statutes provide two layers of protection, two types of protections for employees to not have certain medical marijuana activities used when we are making a decision about either hiring or taking what we would call adverse employment action, basically discipline. The first of the protections applies to all employees. Doesn't matter if they're safety sensitive or otherwise. You've heard that term, and we'll talk at length about that. But the first one is the medical marijuana statutes did not repeal any of the criminal statutes that relate to drug possession or use or distribution. What they did is they carved out a narrow exception. So one of the first things I always talk about when talk about medical marijuana is all the statutes that were in effect before the state question are still on the books. These statutes exist outside our Controlled Substances Act, and they provide a narrow exception. The first thing that a person must do if they want to avail themselves of the medical marijuana statutes is they have to get a license. It's what's called a patient license. The first job protection that exists is that we cannot use the fact that an employee or applicant for a position has a patient license. We cannot use that as the basis to take any form of employment action, be it failure to hire or disciplinary action. So that's going to apply to everybody. Merely having a card does not provide the employer with any basis to take action. The second protection is more limited. When the statutes were originally adopted, they were very broad and restricting employers on their ability to discipline employees for testing positive for THC, which is the psychoactive component, delta-9 tetrahydrocannabinol, I think is how it's pronounced. That's the substance that you'll see pop on a drug test, and that's the psychoactive substance in marijuana. The legislature revised what the state question did and said that the protection against using a positive drug test for THC only applies to non-safety sensitive employees. And the protection that exists is that a positive test cannot be used as the sole basis for taking disciplinary action. And we'll spend some time talking about what that means, but the question then becomes, what is safety sensitive? And while we're going to spend some time later in the presentation talking about that, I've given you the reference there to the statute that provides a list of examples of job duties that for the medical marijuana statutes would be considered safety sensitive job duties, which would then exempt an employee who performs those kinds of duties from the job protection in the statute. Just want to note two things that are not protected by the statute. First, even if you've got a medical marijuana patient license, even if it's otherwise completely legal for you to use, possess, or be under the influence of marijuana, that doesn't extend to the workplace. So the simple way to think about it is the patient license allows an individual to do certain things off the job at home. It does not give any sort of protection for possessing marijuana at work, using it at work, or being under the influence at work. The other thing that should go without saying is these protections are only going to apply if the individual has a patient license. If the individual doesn't have a patient license, then use, possession, or intoxication is per se illegal and can be used as a basis to take disciplinary action. There we go. The next two things I want to talk about are the drug testing statutes and how they interplay with the Fourth Amendment. And the reason that we bring up the Fourth Amendment is the medical marijuana statutes, the drug testing statutes, they apply generally to all employers. As public employers, we have some added restrictions, some added handcuffs on us, namely the Fourth Amendment. And so we need to keep those in mind when we're talking about medical marijuana and how it impacts the workplace. First, let's talk about the drug testing statutes. I've given you the reference. It's the Oklahoma Standards for Workplace Drug and Alcohol Testing Act. This is a statute that first only applies to employees. Last year, we had quite a few questions about drug testing for volunteer firefighters, reserve police officers who don't receive compensation. The drug testing statutes only apply to employees. It doesn't necessarily mean that you can't ask a volunteer to undergo drug testing. It just means that the statutes don't apply to it. The statutes, come on, Bessie. There we go. The statutes identify certain types of drug and alcohol tests that we can conduct. The first group of tests are going to be tests that can be used for basically everybody. The first is a pre-employment test. That doesn't apply to employees, obviously. It's going to apply to people who want to be employees, but it's not limited based upon the job they're applying for. Most people don't understand this, or they simply don't take advantage of it, but technically speaking, the pre-employment drug test can also be used if somebody's applying to move to a different job within the city or is moving from department to department. You can require that they essentially go through the process like they were brand new. My understanding is that most employers don't require that, and they just do an initial at employment pre-employment drug test. The statutes refer to what they call for cause testing. I'm going to call it reasonable suspicion testing for reasons we'll talk about, but this is essentially going to be testing for somebody that we have a reason to believe is intoxicated. That's not going to be restricted to certain types of employees. If you have an employee that is exhibiting signs of impairment or intoxication, the statute will allow you to test them under what the statute calls a for cause test. The other one that's applicable to all employees is what's called a post-accident test. The statute authorizes us to test those individuals, and it isn't limited to particular classes of individuals. What it's limited to is they have to have been involved in an accident that involved damage to property or injury to persons. The statute used to put a threshold on the property damage, but they've removed that because, quite frankly, it was, I think, $500, and I can tell you from a claims perspective, it's very hard to get involved in, say, an auto accident where you don't have $500 in damage. The next group of statutes, or the next group of tests, are ones that only apply to certain people. The first one is post-rehabilitation. If you have an employee who tests positive, you allow them to keep their job but require them to go through substance abuse counseling. You can require them for a period of time to submit to regular drug tests. It's not something that's going to apply to everybody. It's going to be individualized to that employee based on a prior positive test and for a limited period of time. Then we have a couple of tests that are authorized, but only for what we would call safety sensitive employees. The first is random. That's going to be a test that you aren't picking and choosing who goes. It's just a random selection of individuals. Some people know this, but others don't. The statutes were amended a few years ago to, it used to be you would throw all your employees into one group and do a random poll of a certain percentage. The statutes now allow you to take subgroups, say police, fire, and split those out and have separate little pools that you do a poll from so that you make sure you get somebody from each department. The other that most people don't take advantage of and don't have reason to is for safety sensitive employees. You can also have regularly scheduled tests. You can have return from an extended leave, like sick leave test, or fitness for duty. Not going to spend much time talking about those just because it's very nuanced and most people don't use it, but that is in the statute. All right. One thing that I want to make clear, if you are going to engage in drug and alcohol testing, you must have a written policy, and the statute outlines that you must have a detailed policy. And I've given you the reference. It's in Title 40 at Section 555. It'll outline what you have to have in your policy. It used to drive me absolutely crazy before I came to OMAG doing union negotiations, and the state FOP would come in and say, yeah, we agree to drug testing. Let's just put a provision in there. It says we'll follow state law. Well, that's not good enough. We actually have to have a policy that outlines and covers certain topics. Otherwise, we can't engage in drug testing. The records by statute are confidential. There are certain reasons that you can use it. And one of them would be, for example, if you fired an employee for being intoxicated at work and they applied for unemployment, generally the record is confidential, but it can be used for specific purposes. And I've given you the statute if you want to see what the exceptions are to the confidentiality. You can take disciplinary action against an employee if they refuse to take a test or if they test positive. We're going to have a little caveat on that when it comes to THC and people who are non-safety sensitive, and the only thing we have on them is the positive test for THC. But in general, the statute authorizes employers to take disciplinary action if they refuse to test or if they come back positive. The statute provides that if we do drug testing in a way that violates the statute, we test people that doesn't authorize us to test, or we test under conditions which are not authorized by statute, then it actually creates what we call a civil cause of action, a right of action. They can sue you, sue the city, and if they win, they can recover the amount of money that they lost because of the disciplinary action or the failure to hire. They deduct out what they earned or could have earned in the interim from when you let them go to when they actually get a judgment. It also provides that they can get essentially a double recovery. So if you were out $10,000, it allows the jury to award $10,000 in actuals, and another $10,000 is what they call liquidated damages. The other concern on these is that it is in what we call a attorney fee case, which means that that $10,000 in actuals, $10,000 in liquidated rolls up to $20,000. But if their attorney spent enough time on it to be able to bill $100,000, you'd be on the hook for that as well. Because we are the government, we do have certain constraints on our ability to take certain actions and to do certain things. Basic rule of thumb, just because we accept public employment, and I say we because I'm a public employee by virtue of working for OMAG, public employees don't surrender their constitutional rights when they walk through the door and accept public employment. The most obvious ones that come into play, your First Amendment right to speak your mind, your Fourth Amendment right against unreasonable searches and seizures, your Fifth Amendment right not to incriminate yourself. These come up quite a bit in the employment context. The courts have grappled with how to deal with these rights, and essentially have come to conclusions that they need to be relaxed. There needs to be different rules when the government acts as an employer as opposed to the government interacting with citizens. And so we've got some pretty good definition under the First Amendment and under the Fifth Amendment as to how those rules, those general constitutional rules, apply in public employment context. Important under the Fifth Amendment and also the Fourth Amendment, these are rights which citizens can generally waive. Anybody who's watched any cop show on TV has heard Miranda. You have the right to remain silent, but you can waive it. You have a right not to have a police officer engage in an unreasonable search without a warrant, but you can waive your rights. The courts recognize that in the employment context, especially when dealing with current employees, you get into a situation when you are requiring a knowing and voluntary waiver. Can you really voluntarily waive your Fourth Amendment rights, your Fifth Amendment rights? If I tell you as your boss, you're going to take a drug test, you're going to answer my questions about possible embezzlement, and if you don't, I will fire you. The basic compromise is that the courts give us leeway while recognizing that there may be limitations on how we can use the information we acquire when we hang somebody's job over their head in requiring them to do something. And I make the reference to Garrity. Many of you have probably heard of the Garrity case. It's basically stands for the proposition when you're questioning somebody because you can fire them for not answering your questions, they can't really voluntarily waive their rights. They're kind of compelled under threat of termination to answer your questions. And so that's why we get Garrity, which says, yeah, government, they can't invoke their Fifth Amendment rights and refuse to talk to you, but in return, you can't turn over what they give you for criminal prosecution. I note that because it can have some implications in the Fourth Amendment context. The reason that this is key is we talked about under the statute that you can get sued and that they've got the limitation on damages. They can get their actual lost wages plus double that amount for liquidated damages. If we violate the statute, that's what applies. If we do drug testing that also violates the Fourth Amendment, we can be sued under Section 1983, 42 USC Section 1983. It's a statute that Congress adopted to allow for a remedy for people who felt that their constitutional rights were violated. It's a dangerous, dangerous provision because there's no limit on the damages that they can recover. They can sue, they actually primarily end up suing the individuals who they allege violated their constitutional rights. In fact, they can only sue the city or the town if they can show that the town or city as an entity caused the violation, and that's through some policy, practice, or custom. And then there are also attorney fee cases. And those cases can be very expensive to litigate, which means that they can be very significant in terms of the civil exposure just due to the attorney fees. When it comes to the Fourth Amendment, unlike other constitutional rights where they give you a little bit of leeway to accidentally, sort of minor violation of the rights, the courts have made it very clear the Fourth Amendment is an absolute. You don't kind of just sort of violate it. There's no exception for what they call de minimis injuries. You either violate the Fourth Amendment or you don't, but they don't give you that leeway to sort of just kind of violate it, but it really wasn't that bad. It's a simple yes, no proposition. You either violated it or you didn't. There we go. The court has long since held that when we're talking about drug and alcohol testing, be it by law enforcement or by a public employer, that is considered a search under the Fourth Amendment, and therefore it is subject to the Fourth Amendment's constraints. When it comes to the Fourth Amendment, the Fourth Amendment's a bit of a frustrating amendment when it comes to public employment, because the Supreme Court has never been able to agree on a test, like the single test that applies when we're talking about workplace search and seizure by the government. They've given us a couple tests, but they've never been able to agree on the definitive test. While that is generally true, and so if you call me and you have questions about whether or not you can search an employee's desk because you have reason to think that they have something in there they shouldn't, I can walk you through what the two different tests that they've articulated are, and we can evaluate whether or not that would be a violation. But when it comes to drug and alcohol testing, they actually have given us they've given us very good guidance on what is and is not authorized. So generally speaking, we don't have a good guidance as to what the precise rule is under the Fourth Amendment for workplace searches by the government employer, but for drug testing, we do. Fourth Amendment, both in general and as it relates to the public employees, you're going to have one of two things in order for a search to be reasonable. And that's what the Fourth Amendment is all about. It's a protection against unreasonable searches and seizures. A search is only reasonable if either, number one, there is a degree of individualized suspicion that meets the standards that the courts have articulated. So we've got a specific reason to believe that a specific employee needs to be searched. Or without suspicion, individual suspicion, a search can be reasonable if it meets one of the, quote, special needs exceptions that the courts have articulated. Come on, there we go. When we're talking about the Fourth Amendment and we're talking about warrantless searches, the court has made it very clear that there is a presumption that a search is unreasonable if it's not supported by a warrant, and that it is the government's burden to show that one of the exceptions, whether it's individualized suspicion or the special needs, it is the government's burden to show that they essentially met that burden, that they had the requisite individual suspicion, or that they were properly exercising an exception for a special need. For employment drug and alcohol testing, the individualized suspicion is what we call reasonable suspicion. When we're talking to cops and training cops, they're very well familiar with the concepts of probable cause and reasonable suspicion. The concepts that they've established for them in the law enforcement setting have carried over into the employment setting as it relates to reasonable suspicion. In the short version, especially for those of you that work with law enforcement in your communities, reasonable suspicion is what a cop needs to detain you. It's not enough to arrest somebody, not enough to issue a charge, but it is enough for them to stop somebody and basically not allow them to go anywhere and question them to try and see if they can develop probable cause. And because we have it in the law enforcement context, we've got quite a bit of guidance from the courts as to how we evaluate whether or not we have reasonable suspicion. Reasonable suspicion is about what you know. It's not about what you don't. It's got to be something more than a hunch. You've got to actually have information. It's not enough to just make assumptions or have a hunch. But it's also one of those things where you might be confronted with several different facts, any one of which may not get you there, may not be enough to reach a conclusion that you have reasonable suspicion to think something's going on. The court's going to look at it what they call in the totality of the circumstances. And what that means is, show me everything that you've got and we'll look at it all. We're not going to divide and conquer and just look at one particular fact and see if that gave you enough for reasonable suspicion. It's the whole picture. It's about probabilities. It's not about certainty. Reasonable suspicion is not proof that it is more likely than not that something occurred. So in the drug testing context, it doesn't require proof that it's more likely than not the employee is intoxicated. It also doesn't take into account that there might be an innocent explanation. You know, when we're talking about, one of the things we'll talk about on specific things you can look for would be watery eyes. Watery eyes can be consistent with using an intoxicant. It can also be consistent with living in Oklahoma and having bad allergies. The fact that there might be an innocent explanation doesn't mean that there's not a valid suspicion that might exist as well. And so you don't have to have enough to prove to a civil jury that it's more likely than not, preponderance of the evidence. You don't have to have that much. It's less than that, but it's got to be based on actual information and probabilities that are reasonable. Normally, and when you see these in the law enforcement context, but it really is relevant when we talk about drug testing, if a employee is evaluating whether or not they have reasonable suspicion and the employee has some form of specialized training, the courts will take that into account when deciding whether or not they reached reasonable conclusions, reasonable inferences about the information they were presented with. Put differently, I may not, if I've never had training, I may not be able to spot all the signs of intoxication that a cop could because they've got specialized training. But the court has made it clear, including this year in a case called Kansas versus Glover, that specialized training is not required to reach certain reasonable conclusions and inferences. Believe it or not, common sense actually applies too. You know, so put differently, if you encounter me at OML next year and I have the odor of alcohol in my breath because it's OML and, you know, we have a good time during some of those evenings, you don't have to be a cop to be able to figure out, he might have been drinking. That's just common sense. So you are allowed to reach common sense conclusions about how you interpret facts that you're confronted with. Specialized training can allow you to reach additional conclusions that, you know, Joe Blow or Pat Love, who's not trained, may not be able to spot. So you don't have to have specialized training, but if you do, it can help to justify why you have reached a conclusion that you did, a conclusion that the normal run-of-the-mill person may not reach. The ultimate question that the court is going to ask when we're talking about drug testing is, based on the information that you had, did you have reasonable suspicion to believe that the employee was engaging in unlawful activity involving controlled substances? That is the use of them, that's the possession, and it also includes impairment while on the job. Now, when we're talking about testing that does not relate to an individualized reasonable suspicion, we've got a couple of clear examples. Post-accident testing. Post-accident testing is not based upon, you don't have to wait till you get to the employee who was in the auto accident and evaluate them to see if they might be intoxicated. The court has determined that this is a special need for the government and that it will authorize the government to go ahead and get the sample collected, get the test done, primarily because depending on the scope of the accident, you may not have time to fully evaluate whether or not impairment might have been at play and then determine that you want to go get them tested. They essentially say, go get the sample now, go get the test, and then you get the results while you're evaluating the accident, while you're investigating it, and you can take that information from the test and use it as part of the investigation to see, were they impaired, did that contribute to the accident? But it doesn't require individualized suspicion. The other one, of course, is random testing. Random testing is not about any particular individual. It's not based on any facts other than that they're employed, and they're employed in a specialized or a safety-sensitive position. There's nothing individual to them that gives us a lawful basis to test them. It's an exception to the rule. It's a special need. The reason it applies to safety sensitive is because the courts have said there are certain job duties that people perform that you cannot have drug abuse and alcohol abuse. So we're going to do away with the individualized requirement and allow you to test those people without individual reasonable suspicion. But as it relates to these two, anytime that we're talking about testing or a search under the Fourth Amendment that is not justified by individualized suspicion, the court really doesn't want you to have discretion. They want it to be an objective standard, and they want you to be consistent. They hate discretion. They hate testing without a lack of suspicion. So when you've got post-accident testing, you don't want to have it to where it's, if an employee is involved in an accident and there's either damage to property or injury to person, we may test them. Well, if it's really up to discretion to decide when, and sort of we get to pick and choose who we send for testing, the courts don't like that. They really do not like that. They also don't like if you do random testing by pulling a list of employees and then picking out individual names and deciding who you want to randomly test. They're going to want things to be objective, and they're going to want you to consistently apply your policy. The other thing I'll note without going into too much depth is a drug testing program that otherwise on paper looks sufficient can be held to violate the Fourth Amendment if it's not implemented in a way that's actually designed to deter drug abuse and detect drug use and deter abuse. What that effectively means is if you have, and it goes back to consistency, if you have post-accident testing on the books, but you've had 20 auto accidents in the last 5 years and you never, ever went and tested anybody until all of a sudden John Doe got into an accident, you went and tested him, the court can look at that and say, well, it technically met the exception for the Fourth Amendment. It technically met the statutory criteria. You have not implemented your drug testing in a way that is consistent in an effort to detect drug abuse and deter its use. And they can find that it's a violation of the Fourth Amendment. So what I hope you'll take away from this is if we're going to have drug testing on the books, we need to be consistent with it. We need to actually use it. Now, when we're talking about reasonable suspicion, or when we're talking about safety sensitive, there is a difference between what the statutes consider to be safety sensitive and what the Constitution might consider. For constitutional purposes, the courts are going to look at and remind us that this is an exception to the rule. We are given the authority to test randomly employees who are safety sensitive without individualized suspicion. And because it's an exception to the rule, they want to make sure that you actually are classifying these people properly. For constitutional purposes, a safety-sensitive job is one where safety is, quote, an important concern. The court has said that These are the kinds of jobs where even a momentary lapse of attention can have disastrous consequences. It doesn't require that they perform those duties where if you had a momentary lapse of attention, it could have disastrous consequences. They don't have to do that 24/7. They can do it on a sporadic or on-call basis and still be safety sensitive. But you're gonna actually have to show that it's the kind of job where you can't even have a momentary lapse of attention. That's why we look at the most obvious ones are police, fire, and dispatch. Frankly, dispatch is the kind of job that most of the time, if there's a momentary lapse of attention from the dispatcher, it's not going to have disastrous consequences. But sometimes there are. And if we're in a critical incident or we're dealing with something extremely serious, we can't have a momentary lapse of attention. My rule of thumb that I use when deciding if something's safety sensitive is, would, for example, Homeland Security consider it safety sensitive? Think about employees that work at the water plant and do the water treatment. If they have a lapse of attention, they can screw up the drinking water and affect everybody. But does that mean that, and with no disrespect to everybody that's on the call, but do your job duties, if you had a momentary lapse, would there be disastrous consequences? Probably not, but there might be certain things you do that it could be disastrous. But we have to distinguish that we're going to have separate positions, some of which are clearly safety sensitive and some of which for constitutional purposes aren't. The medical marijuana statutes give you that list, and I gave you the statute there again, of the types of job duties that can be considered safety sensitive. The list is pretty good, and most of what they have outlined in there is going to qualify constitutionally, but it's that reminder that this is a statute that applies to all employers and is not just taking into account the Fourth Amendment restrictions. There are some duties that are listed within that list that, quite frankly, are not going to be constitutionally safety sensitive positions. And I'll give you, the example of critical infrastructure. One of the exceptions or one of the definitions in the medical marijuana statutes is you're safety sensitive if you do job duties that include the operation, maintenance, or oversight of critical services and infrastructure. Clearly, if you're operating the gas system or the water, or you're doing the water treatment, if you're the operator, yeah, you're going to meet the definition for safety sensitive from a constitutional perspective. But if you're the supervisor who never actually touches the lines, who never actually treats the water, who doesn't do the actual legwork, technically under the medical marijuana statutes, they'll call you safety sensitive because you are overseeing the critical infrastructure. But keep in mind that qualification from the courts, where a momentary lapse of attention can have disastrous consequences. The provisions in the medical marijuana statutes are mostly consistent and are going to overlap with the Fourth Amendment. But the closer we get to, well, technically under the statute, it doesn't really feel like safety sensitive, but technically it meets the medical marijuana statute. There are job duties listed there that are going to fall outside the Fourth Amendment. So if you're wanting to conceptualize it, think of the Fourth Amendment as a circle, the medical marijuana statute as a circle that's on top of it, that's slightly bigger than the Fourth Amendment circle. There are going to be some duties that are just going to fall outside the constitutional restriction for safety sensitive. All right, let's talk about reasonable suspicion. Remember, reasonable suspicion is about what you know. It's about what you know, and importantly, when did you know it? The courts are going to evaluate if you do a reasonable suspicion, what the statute calls for cause. If you're going to do that kind of drug test, they're going to evaluate whether you have reasonable suspicion at the time you ordered the test. We may discover things later that you may send somebody because they're looking a little hinky, and we've got a couple of observations that we think they might be high. And after they're at the drug test and we're waiting for the result, somebody comes in and says, hey, I saw him smoke a joint at lunch. What we learn after the fact cannot be used to justify why we sent them for the test. It is only going to be about what we knew in the moment. So that means information we acquire afterwards, including the positive test result itself. If we didn't have reasonable suspicion, we can't hold up the test result and say, but see, they were high. It says so right there. It's not going to matter. It's going to matter about what we knew and when we knew it. That's where documentation can become critical. My recommendation to you would be that before anybody is sent for a reasonable suspicion drug test, document. What did you know? When did you know it? Here's the information that we had before we sent them for the test. And this is why we sent them for the test. You're going to have access to information that you or your employees are going to personally observe certain behavior, certain things that might give you a basis to send somebody for a drug test. You can also rely on information that you get from third parties. When you rely on that third party information, you need to evaluate it for the reliability. For example, is it somebody you know? Is it somebody who identifies themselves, who gives you information, their address, their phone number, you meet with them in person? Or is this an anonymous tip that you got? And it's not that anonymous information can't be relevant, it just doesn't have the degree of reliability that getting information from a known third party who you can hold accountable if it turns out that they lied. The courts are going to give more credibility to information from a known third party than an anonymous source. Do they have a motivation to lie? If you have an employee who's going through a bad breakup or divorce, and all of a sudden their jilted ex calls and says, well, they use weed all the time right before work. Well, you have a known third party, and so you can evaluate that information, and there is some extra credibility based on the fact that you know who they are, they have a close relationship with the employee, but you can't ignore the fact that they also have a motivation to lie. The other thing to consider when evaluating information that third parties are bringing you, are they bringing you the information contemporaneously when they saw it, or is this after the fact? And I'll use myself as an example. I try most mornings during the work week to go out for a run, and there is a Oklahoma City Public Works employee who right about 6:30 drives through our neighborhood, and there was a day that I damn near got knocked over from the stench of burnt marijuana as he drove by in his City of Oklahoma City truck. If I call that in right then that is a contemporaneous report from a known third party. I'd given my information. That suggests, because it's contemporaneous, I just saw it, I just smelled it. That is far more relevant than if I call the next day. If I call the next day, that doesn't really tell the city that they have reliable information that the employee is using or under the influence of marijuana today. It's that they were yesterday. But if the purpose of testing is to determine what's going on today, information about what happened after the fact, days later, is not going to be as reliable and not provide us enough reasonable suspicion as it would if we were getting the information in the moment or shortly after somebody observed something. One question that we get is, well, do we get to take into account that we know that they have a medical marijuana patient license? Because, I mean, come on, if they have the license, they use weed, right? I do not believe that it should factor into your analysis for reasonable suspicion. And the reason is simple. Medical marijuana is still illegal. It's illegal federally, and it's illegal in Oklahoma for anybody that doesn't have a patient license. The only thing that the patient license really suggests to you is that the person has gone through the proper legal steps to engage in activity lawfully. It really doesn't suggest anything that they would be using it unlawfully. Put differently, knowing that they have a patient license only tells you that they are trying to comply with the law, not break the law. I would not use the fact that an employee has a patient license as a basis to reach a conclusion that that means they must be high here at work. I would not let that factor into your analysis at all. So again, circle back, the test is based on what we know, not what we don't. Would a reasonable person suspect that the employee was engaged in on-the-job use, possession, or impairment? Talking about marijuana, or it could be alcohol or any other drug, but that's your legal standard. Do you have a reasonable basis to suspect that they're doing it? Not that they are, in fact, more likely than not doing it, but it's more than a hunch, and it's based on actual information. Would a reasonable person suspect use, possession, or impairment? The drug testing statutes give you what I would call a non-exhaustive list of examples of the type of things that you can look for that would justify a reasonable suspicion test. Some of them are obvious. Actually having drugs or alcohol on their person or in their vicinity, conduct that suggests impairment, a reliable report that they've actually used while on duty or at work, information that they tampered with the drug test. It's pretty good indication that if they go for a drug test and they tamper with it, that they don't want you to find out what the test would yield. Then there are some looser ones that we'll talk about, which are negative performance patterns. excessive or unexplained absenteeism or tardiness. The thing that I would remind you, much like the medical marijuana statutes, the drug testing statutes apply to all employers. As public employers, we have the added layer of the Fourth Amendment that has to be taken into account. I've given you the O'Connor versus Ortega. That's, believe it or not, 1987 was the very first time the Supreme Court ever decided to answer the question of, do public employers have to go get a judge to issue a search warrant before they can search their own desks, before they can search their own file cabinets at the public workplace? This is the case that still has never been resolved, where we get two different tests, because believe it or not, back in 1987, 4 of the 9 justices thought you should have to go get a warrant before you do any form of search at your own workplace. Luckily, reason prevailed, and 5 of them, a majority, agreed you don't have to go get a warrant. But they could not then, and they have never been able to since then, agree on what the test is. Justice Scalia, who was in the majority, his test would be, if it's reasonable for private employers, it's reasonable for public employers. And if that test prevailed, then those statutory examples that private employers can use to justify a reasonable suspicion drug test, you'd be able to use. But he was alone. He was in the majority, but he did not have a majority that signed on to his opinion. That's where we get Justice O'Connor's opinion for the remaining 4. She outlined a test I'm not going to go into today, but the reason I put it up there is to let you know that the court had an argument before it that if it's reasonable for private employers, it should be reasonable for public. They've never signed off on that. And so I'm still of the mindset that there are going to be added layers from the Fourth Amendment that might restrict us more than it would restrict a private employer when doing reasonable suspicion drug testing. Again, totality of the circumstances. It's the entire picture, all the information that you have. When we're talking about totality of the circumstance, you may have one fact that on its own gives us what we need. If somebody sees an employee, you get a verified report that somebody saw an employee smoking a joint at lunch, that's going to be enough in and of itself to suggest that they were using or might be impaired while on duty. Oftentimes you don't get that one smoking gun fact. And that's where you can get several different facts. And what the courts essentially say is, look, we don't do divide and conquer. We don't say, well, this fact, watery eyes doesn't get you there. Well, this fact doesn't get you there. They're going to take them all into consideration, look at the whole picture, and decide if you had reasonable basis to suspect more than a hunch, you had a reasonable basis to believe that they were engaged in either the use, possession, or impairment while on duty. So let's talk about those squishy examples that are in the statute. Negative performance pattern. Well, what kind of negative performance? Just not doing your job very well doesn't suggest you're high. There's got to be something about the performance that would link it back to impairment, possession, or use. So just because their performance has slipped does not in and of itself give you reasonable suspicion. Got to ask a few more questions. What are we seeing about their performance, and what other information do we have that would suggest their negative performance might be linked back to drug abuse or alcohol abuse? Absenteeism and tardiness. Again, it's on its own, it's probably not going to be enough to suggest that they're impaired or possessing or using on duty, but combined with other facts, we can piece together a puzzle that might suggest that possession, use, or impairment of either a drug or alcohol might be contributing to the absenteeism or tardiness. This is where we go back to totality of the circumstances. On its own, is it enough? Probably not. Could it, when coupled with other actual information that we have, give us a reasonable basis to suspect that drug or alcohol abuse is at play? Yes, it can. All right, so here are a couple things to keep in mind when we're talking about the behavior of the employee, not just their job performance, but their behavior, what we're seeing from them. How do we evaluate that to determine if they might be intoxicated? Well, specialized training is not required, but it does allow people who are trained to reach conclusions that a lay person wouldn't. Keep in mind, you have to distinguish between what you assume and what you know. What you know, actual facts, actual observations, you can make reasonable inferences based on what we all understand from our everyday life. And we'll go back to the example of, you don't have to be a cop to know that if you smell alcohol on somebody's breath, they might have been drinking. You don't have to be a cop to know that if somebody walks by you and you just smell the stench of burnt marijuana coming from their person, you don't have to be a cop to know that they probably just smoked out. Although you might be somebody who goes, what does that smell? But you don't have to have that specialized training. Specialized training allows you to pick up on things that the ordinary person wouldn't, but we're allowed to be people. We're allowed to rely upon our common sense and understanding when evaluating facts. One thing that I absolutely hate seeing in police reports and hate seeing in employment records is generalized statements. Well, we drug tested them. Why? Well, because they were acting funny. They were tweaking. They seemed kind of spacey. Generalized statements, generalized conclusions don't do anything for us. Why were they acting funny? What were they doing? Why do you think they were tweaking? What did you see? They were spacey. Well, give me an example. Give me concrete information. Don't just give me the conclusion. Don't just give me a generalized statement or conclusion. Give us concrete, factual basis that you think that something is off. Sometimes you're not going to need a second set of eyes, but the general recommendation is when it's feasible, get somebody else to come take a look and get them to take a look without telling them too much about what you are seeing. Just tell them that you think something's off and will you tell me what you see? Let them independently go be around the employee and see what they see. And of course, you need to document what you see, have them document what they saw. Most of the time, this is going to be a recommendation. There will be exceptions. For example, you don't have to go have a face-to-face meeting with the employee if you see them chugging from a bottle of tequila out in the parking lot. Don't really need a face-to-face meeting with the employee to figure out if they might have just drank alcohol. Many times, though, you're going to see little clues that suggest something is off. You're going to want to meet with the employee face-to-face, not necessarily to interrogate them about whether they're high or drunk, but to have a conversation so you can get a little bit closer and make additional observations to see if there's enough to reasonably believe that they might be intoxicated or impaired. Now, SHRM, the Society for Human Resources Management, they've got an excellent list of examples of things to look for on their website, so I'm going to give them full credit here. What do you smell? The odor of alcohol, the odor of marijuana, and in this case, I'm not going to say burnt marijuana because keep in mind, burnt marijuana suggests use. You actually burnt the marijuana to smoke it. Fresh marijuana, of course, doesn't indicate you used it, but keep in mind, we can drug test based upon use, impairment, or possession at the workplace. So if somebody walks into City Hall to show up for work and they just reek of fresh marijuana, that's a pretty reasonable basis to believe they might have marijuana on them. And the statute does not allow them to have marijuana at work. What are you seeing from their movement? Are they unsteady on their feet? Did they fall? Are they kind of fidgety? And that's not how they normally are. And that's an important point. When you're telling and you're documenting, here's what I've seen. If you have been around the employee, tell us why that's different. They were really fidgety today, and that's not how they normally are. Did you see or did they complain about being dizzy? These are certain things that might suggest impairment while they're at the workplace. Again, remember, it's not about what's more likely than not the case. There are innocent reasons why somebody might be unsteady on their feet, why they might be fidgety, why they might be dizzy. The court's not looking for certainty, they're looking for probabilities. Yes, being fidgety might just be because I was up late and I drank a whole bunch of coffee and I'm just kind of fidgety today. It might also suggest that I'm under the influence. It can be consistent with both without eliminating reasonable suspicion. This is one that's going to be a little bit more difficult for people who don't know to look for it, but what do you see in their eyes? Watery eyes, red eye, constricted eyes. Are they dilated when they shouldn't be dilated? You're going to need to know a little bit more about what you're looking for there, because most of us, myself included, I don't know that I can tell you unless somebody's eyes are really dilated. I don't know that I can tell you when somebody's dilated versus when they're not. What are you seeing from their face? Are they just all of a sudden really flushed and that's just not how they normally are? Are they sweating profusely and that's not what they normally are and they haven't done anything recently that would cause them to do that? Are they giving you that blank stare? Are they really confused today and they're just normally not that confused? These are all factors which on their own may not get you there, but when taken with other factors might give you a reasonable basis to believe that they're impaired. Speech, anybody who, and I'm going to use OML again just because I really miss not seeing you guys this year at the conference. We all know at the end of that Wednesday night there at the conference, you're going to have some people who have some really fun speech, slurred speech. They're all of a sudden really slow in their talking. They all of a sudden, normally they're on point, but they just are really distracted today mid-thought, and they just trail off. You're trying to ask them basic questions and they can't verbalize the basic information. These are all things that, when taken together with other factors, could support a reasonable inference of intoxication. Many of us have coworkers that are just argumentative by nature. I'm a lawyer. I can be argumentative by nature. Is it out of the norm? Are they above and beyond what normal? Are they more agitated than usual? Are they more irritable? Are they acting drowsy? Are they real argumentative? Again, these factors may not themselves in isolation get us there, but when you couple that with other factors that we've talked about, they might get us there. And also remember, again, there might be an innocent reason that they be acting that way. The possibility of an innocent explanation doesn't eliminate suspicion that you can draw from what you're seeing. Certain inactions. Are they all of a sudden passing out at work? Do you come into their office and they're just unconscious? Unconscious versus catching them napping is going to be different. If you can't wake them up, that's a lot different than, accidentally fell asleep. Are they, when you wake them up, are they completely incoherent and unable to react to your questions? Those are all going to be very strong factors that suggest that they might be impaired. One question that we get a lot is, well, let's just call the cops over. They know this stuff. They can spot it. That's not a bad thing to do, but just keep in mind that when we're talking about drug testing in the employment context, we're talking about a search that is a non-law enforcement search. We can involve our police officers if we want to get their specialized training to help us evaluate something. We ought to make it clear to them and make it clear in the documentation. They were not there to investigate public intoxication. They were there to help us on the administrative side to evaluate whether or not someone might be exhibiting signs of impairment. When we're talking about information about the past, it's not that it's irrelevant, but it is only, the information we know about somebody from the past is only relevant in as much as it might suggest and contribute to our present understanding of whether they are currently impaired, currently possessing, currently using. So for example, if you have an employee who previously was intoxicated at work, it's been a couple of years, now all of a sudden you're seeing the same signs that you saw before, what happened in the past doesn't itself justify sending them for a test, but it does allow us to say, we saw X, Y, and Z, and we know that based on the past, when they act that way, they were intoxicated before. So what happened in the past itself will not justify testing someone, but it can be relevant if it tells us and informs us about what we're seeing today. The last couple slides, I just want to close up with a few practical notes. The first is the job protection when it comes to testing hot for THC only applies to non-safety sensitive, and it only applies as being the sole basis, that we can't use a positive test as the sole basis to take disciplinary action. For safety sensitive employees, positive test, there is no statutory protection. We're back to our at-will employment standard, which for those of you that are in a charter city, you need to look at the charter to see if you're actually at will or the charter changes that relationship. It's those non-safety sensitive employees that the solely because of needs to be taken into account. Now, why we would be random testing a non-safety sensitive employee, we'll set that aside for a second. But keep in mind that a random test doesn't tell us a whole lot about the person because we didn't suspect that they were intoxicated. For post-accident testing, the case where the Supreme Court said that this was a special need, an exception to the individualized suspicion requirement, was the Skinner case. And what the court said is, look, in an accident, it's going to take you a while to evaluate what happened, to try and backtrack and figure out how the accident happened and what actually happened there. And by that point in time, if you detect enough to justify a reasonable suspicion test, too much time is going to have passed. So they're going to let you go ahead and collect the sample today so that you can get that preserved, get that information, and then take it into account when you're evaluating the accident. So if you've got a non-safety sensitive employee who is involved in an auto accident, you get them tested, the fact that they test positive doesn't really tell us anything, and we can't use it as the sole basis to take disciplinary action. But consider this example. If you've got a rear end collision at a stop sign, was the city vehicle the one at the stop sign that got rear-ended, or were they the one that rear-ended the car at the stop sign? If I'm sitting at a stop sign and somebody rear-ends me, if I had a patient license, which I don't, but if I did, and I tested positive for THC, does that tell you anything that I might have contributed to the accident? No. I'm the one who got hit. I'm not the one who was inattentive while driving. If, however, I'm the one that was driving, that test might be relevant as we evaluate what caused the accident, why were you inattentive, and we may need to ask additional questions to see if the person was impaired in the moment. And if we do use that as part of additional information to take action against the employee because of the accident, it is not the sole basis. The test result is not the sole basis for taking action. Now, when we get to a for-cause test, the positive test really becomes very relevant if we have reasonable suspicion to think somebody was intoxicated. But remember, totality of the circumstances. If you sent me for a drug test because you smelled alcohol on my breath and I come back 00 on blood alcohol, did you have reasonable suspicion to think that I was high? Well, no. Now, if what you saw, you didn't smell alcohol, but you saw other indicators of possible impairment, not quite sure if it might be drunk or it might be high, then a positive for THC might have some relevance. But why did we send them for testing? What did we think they were on? If we thought they were drunk, THC really doesn't help us in evaluating that. The blood alcohol is going to help us. Some closing thoughts would be alcohol and THC are just different. When you drink alcohol, it's blood soluble, it gets into your bloodstream right away, it dissipates out of your bloodstream over time, and they scientifically have shown that there's a pretty good one-to-one correlation between your blood alcohol and your impairment. It's not the case with THC. THC is not blood soluble. It's what they call lipid soluble, which for people like me of the larger variety is a nice way of saying fat soluble. It takes the detection of it takes a little bit longer than if it's alcohol. It gets into your bloodstream and can be tested and detected in a urinalysis a little bit later. It's not that much later. But the more important thing is it stores in your fat. It doesn't get out of your system as quickly as alcohol, which means that the impairment can subside and you can still test positive for a period of time. In fact, because it stores in fat, someone who is lawfully smoking, let's say somebody smokes a joint every night, they've got a patient license, but they never use at work. They could quit today and still pop hot for the next 30 days. And so the resulting drug test is not going to tell us as much as it would with alcohol. There's also the issue with edibles. They get into your system. It takes a little longer for them to impair a person than somebody who smokes it. But really the issue or the point I want to make is a positive test for THC suggests that at some point in time in the recent history, they've used THC. It doesn't necessarily suggest that they were intoxicated in the moment. That's where your observations and what you saw in the moment is going to become very important. The thing I want to close on is sort of it's up to you which way you go, but drug and alcohol testing, we've never really had to think of it this way, but if you were testing a person who's applied for a job and the drug test would tell you not that they had a drink before the drug test or during the day, but it could tell you that, hey, over the weekend they had a beer. Would we care? I mean, would we honestly care if we're looking at hiring somebody if they had a beer over the weekend? No, we care if they're going to drink during the day. We care if they're intoxicated during the day at work. But if that was our reality, I think we would view the drug testing results a little bit differently if it was telling us not impairment in the moment, like it would with alcohol, but that they were impaired at some point in the past. So for non-safety sensitive, that's very relevant due to our statutory protections about not using a positive test as the sole basis to take action. For safety sensitive, we get this question quite a bit, and it's really up to your city to decide which way you go. The statute does not require that you hire someone notwithstanding a positive THC test. Does not require that has a patient license. Does not require that you discipline an employee who tests positive for THC. It simply says that there's no job protection. Knowing that we can detect THC use off duty, knowing that people who have gone through the legal process to obtain a patient license are lawfully allowed to engage in medical marijuana use off duty, how does that inform our decision about what we do for safety sensitive positions, either in hiring or in discipline? There's no statutory protection, but if you take the hardline stance that we're simply not going to tolerate it, you may be cutting yourself out from hiring individuals who could be quality employees strictly because they did something that was completely legal while off duty. I cannot tell you the right answer. I just want to make the point so that you can have that conversation and decide what's right for you. The very last point I'm going to make, and I'm perfect there at 1 o'clock, that applies to positions that are not regulated by the feds. The feds have no sense of humor about weed. And so if you're talking about, for example, a CDL, they don't get to use weed. Our state protections don't apply. And if they lose their CDL because of the medical marijuana THC test, that's on them. And if we require the CDL, I'm sorry, but we can't do anything about that. So with that being said, I really appreciate your time, your attention. I'll defer to Aubrey. I don't usually, if we were in person, I would say I'll stay here for as long as anybody wants to answer questions, but I will defer to Aubrey since we are in a virtual meeting room here.
Well, thank you, Matt. We really appreciate your expertise on the subject and definitely learned some new things. So if anyone has questions for him, feel free to use the chat, or there's a Q&A at the bottom. So we'll give you a few minutes if you've got some questions. I was also going to mention, I think we've got everybody accounted for. There's one of you that your name on Zoom just says clerk. So I sent you a chat. If you could respond and just let me know your name so we can make sure you get credit for that. But we'll see if anyone has questions.
I will share this, Aubrey. For about half of our members and half the state of Oklahoma, we now have the issue after the Supreme Court's decision in McGirt that tribal reservations might exist on 48% of Oklahoma. One interesting outcome of that is the basic rule is that the state criminal laws do not apply and that federal law and tribal law apply. One of the fallout of that is that medical marijuana patient licenses, those are all criminal statutes and exceptions to criminal statutes. It doesn't affect you on the administrative employment side, but what it very likely means is that a medical marijuana patient license holder who's possessing while in tribal reservation does not enjoy the state law protection. And of course, it's still illegal under federal law. So I'll just throw that out there as one of the numerous outcomes of the McGirt opinion. Ooh, look at that. We got one from Crystal. All right. I'm going to read it for the group. What about employees that have to go into people's homes and are exposed that way? And then they are randomly tested. My advice on that would be twofold. Number one, your contact high concern there, depending on how long they're in the home, they're going to have to breathe in quite a bit of secondhand smoke for it to really show up on a drug test, but it's not impossible. My recommendation would be document. If the employee, whether it's code enforcement, police, fire, whatever, if they're in a home where they think they were exposed, it is in their best interest and everybody's best interest to write that up and submit it. If they do the drug test and their THC levels are extremely high, no pun intended, that's probably going to be a lot more than just contact exposure while being in the home. But documentation, look, I'm a lawyer. Document. If it's not in writing, it doesn't exist. So that would be my advice: is if the employee thinks that they were exposed to secondhand smoke, they need to document. And Crystal's follow-up: should there be something specific in the drug testing policy to address that possibility? Your drug testing policy is probably going to address the actual use and say that we do not tolerate the actual use of any of these banned substances. By documenting it that way, the question is going to be, did they violate the policy? Having that secondary exposure, that secondhand exposure, is not going to violate the policy, most likely, the way it's written, because they didn't actually use marijuana. They had a secondary exposure. And so probably not, but your drug testing policy, there is no one size fits all drug testing policy unless you want to call Susie, Monica, or myself, and we can give you some examples of drug testing policies. But you're going to want to look at your policy and see what does it actually notify our employees is not permitted. If it's the use of marijuana, and I'm betting now that I think about it, that Crystal was probably wanting to ask also, should we require in the policy that they report it? You could. Frankly, it would be in the employee's best interest, because that positive test, if they're non-safety sensitive, the positive test alone can't do it. But if they are safety sensitive, it's going to be in their best interest to document it. So would be a good advice, and you could definitely put that in for to the policy if you wanted to, that employees thinking they were exposed who did not use drugs but may have been exposed should notify, HR. All right. Jackie's got a question here. I have exposure forms for our employees to fill out. Look at that. Jackie, would you mind, well, okay, before I ask Jackie to do something for the benefit of everybody else, her comment was, I have exposure forms for our employees to fill out if they have been exposed. Is it okay to ask them to do this? The short answer is yes. I mean, it's going to end up being voluntary. Even if it wasn't voluntary, there are certain questions you can ask an employee, and we can go through Garrity and all of that. The thing that I would tell you is that if they do fill that out, I would keep that form in a segregated place where you would keep other non-traditional employment medical records. Just like you're not going to keep the drug test result in the same, the same part of the personnel files you keep their job application. There are going to be certain things you want to keep separated. If you do have them present that the exposure form, I'd probably put that in the same place you put the drug test results. Brenda asked, will we be getting a copy of the presentation via email? I can't answer whether it will be by email, but I know Aubrey said that she's going to share it on the website. But Aubrey, I'll defer to you on that.
Yes, we will put both the video of this presentation as well as the slides up on the OMMS website, and then we'll email out a link to that so you guys can access it later.
And I'm going to do what I started to do, and then decide I should probably answer the question first. Jackie, if you wouldn't mind emailing Aubrey a copy of the form that you use, I'm sure there are some people on the call that may not have those forms, and so that might be helpful for everybody if they could see what kind of forms you're using for secondary exposure. Absolutely, Jackie will do it this afternoon. We appreciate it.
All right, if there's any more questions, send them in. I was going to mention too that the OMMS website is okmms.org. And then I also wanted to let you guys know that OMAG has a sample drug testing policy with that reasonable suspicion checklist in the back of it on their website. And their website is omag.org. And you can find that under free services.
Aubrey, I'm going to do, if you don't mind, I'm going to do a quick shout out here as well. Susie Paulson, our general counsel, started a group, and then her and Monica Coleman, after Monica started, have really been pushing hard with this group. Of course, COVID has made things interesting, but OMAG has helped start a group called OMHRP, the Oklahoma Municipal Human Resources Professionals. They've I'd encourage you to reach out to Susie or Monica, and they can get you hooked up with OMHRP. They were doing every other month in-person meetings with the ability to stream it to those who couldn't come. Obviously, COVID has put a wrinkle on things, but when we get back to some semblance of normal, I anticipate OMHRP getting back up and going again. So if you're not a part of that or don't know about it, please go to our website. You can find it there, or email myself, Susie, Monica. We can get you more information about it. And that's where some of those documents are also stored in addition to our website.
All right.
Wait, let's see here. Please link that email and website for HR. All right. Let me go real quick here to our website and find the link for OMHRP, and I will human resources. OMHRP. All right. Aubrey's the best place going to be to do it under Q&A, or where's going to be the best place for, well, okay. I'll say it and then I'll try and figure out the best place to put it. The website is omhrp.org. And then for everybody at OMAG, if you want to send us an email, all of our emails are simple. It is the first initial of our first name and then our full last name. So mlove@omag.org, spaulson@omag.org, mcoleman@omag.org. You can also give us a call. Our main number is 405-657-1400.
And I stuck it in the chat for you there, so you guys should be able to copy and paste that.
And obviously you can find our website at omag.org. So.
All right, if there's not any more questions, oh, maybe one more. Oh, okay, perfect, Amy, you got it. All right, well, thank you again, Matt. We appreciate it. Our next webinar will be next Wednesday at noon, same Zoom login. It'll be David Weatherford, and he'll be talking about creating agendas, ordinances, and resolutions. So some practical info for you guys on that one. So if you have questions, just email me, and we'll see hopefully some of you next week. Thanks again, Matt.
Thank you guys. Really appreciate the opportunity.